Today we're going to cover the important topic of property defects and how they are addressed during the presentation and the buying process. Defects fall into one of two categories. They're either patent defects or latent defects. And it's very important that buyers and sellers are aware of the differences and that they conduct themselves properly when presenting, identifying, and documenting any issues regarding property defects. Hi, I'm Jerry Chopik, and I'm a licensed realtor in Ontario with Right at Home Realty, the #1 brokerage in the GTA since 2013 and the largest independent brokerage in Canada. I'm a member of the Canadian Real Estate Association, the Real Estate Council of Ontario, and the Toronto Real Estate Board. This video is part of my educational series on realhelpfulrealestate.com and torontocondo.ca. For the record, I'm not a lawyer. I do not give legal advice. And this information is provided to you free of charge for educational purposes only. It's not to be interpreted as legal advice. If you are experiencing any legal difficulties, it is important that you discuss your situation with a qualified lawyer. Now, an overview of patent defects versus latent defects. What is the difference and why is this important? Patent defects are those that can be readily discovered by ordinary vigilance on part of the purchaser or through a home inspection. When it comes to patent defects, the typical rule is, they're there and, caveat emptor, or the buyer beware. Latent defects, on the other hand, are those that for various reasons would not necessarily be identified by, a general inquiry or an assessment which a purchaser is in a position to undertake before actually contracting to purchase the property. A seller is under no obligation to disclose a patent defect because a purchaser could have or should have, detected that defect, by doing reasonable investigation of the home, either personally, or by hiring a home inspector. For example, if a railing is broken or there's some obvious signs of water damage, you have no legal recourse against the vendor after purchasing the home. It's a patent defect and you should have seen that. Now, examples of patent defects would be such things as noticeable brickwork problems, perhaps mold from excess humidity or water seeping in through basement walls, but maybe visible roof problems. Patent defects, although they do not have to be disclosed, a word of caution here. Where a seller undertakes efforts to conceal a patent defect, that preventing the buyer from seeing it in order to mislead the purchaser, or purposely downplays the buyer's suspicion, this action, might be considered fraudulent, and the purchaser might have a legal right to recover against the seller as a result of future problems. For example, oh, that water stain, oh, that's not an issue. It's been that way for decades. But later, when the buyer discovers that that basement floods every spring, that's an issue, and the buyer might be in a position to pursue costs for remediation. Likewise, if a seller is aware of a latent defect and has failed to disclose this to the purchaser, this could be construed as a misrepresentation and give the purchaser a legal right to recover against the vendor. Examples of latent defects, not readily visible could include such things as, contaminated soil or contaminated water, the presence of asbestos or urethral formaldehyde, UFI, or a portion of the home that perhaps caught fire at some point, since been repaired, but nonetheless should be divulged. If a seller or the agent is aware of a latent defect, real estate law dictates that it must be divulged to the buyer as soon as reasonably possible, including before an offer is actually made by the buyer. So how do you protect yourself as a purchaser? And as a seller, how do you stay clear of misrepresentation and potential legal issues down the road? The following points are presented from the buyer's perspective, but it also highlights throughout the responsibilities of the seller. Well, the most obvious first step for the buyer is to include a home inspection as a condition in the agreement of purchase and sale. This is pretty much standard today, at least in the GTA. You hire a competent home inspector to investigate your potential new home. A good home inspector will ensure that you are well aware of any patent defects before you firm up the sale. You'll have a formal report in hand and a list of items to discuss with the seller, should you feel that that is warranted. Also, take the time to do your own thorough investigation of the homes. Don't be rushed. Don't be satisfied with what the vendor or the vendor's realtor might tell you about the state of the home, through your own realtor. Conduct whatever poking and prodding and due diligence is required in order to be satisfied that your potential home is in a condition that you're going to find acceptable. Almost every home will have some issues to be addressed. They're not perfect, or to be addressed in the near future. Like, for example, the need for a new roof in the next 5 years. You may not know that, but your inspector should tell you that. But given the price and other factors, these issues that are brought up might be very acceptable to you. But the bottom line is, know exactly what you're purchasing. In Ontario, an optional seller property information sheet, an SPIS, it's referred to as a Form 220, is sometimes provided by the vendor. This form summarizes major aspects about the general condition of the home. If it's provided, carefully review the information that's available and dig into any concerns that you might have. As I said, it's general in scope, rather broad, so if there's any remarks in there that cause you some concern, delve into them. Dig into them and obtain more details. Also suggest you keep a record of your requests and your discussions, because having this documentation as a backup could prove important in the future, should any problems arise. It's important to remember that contracts of purchase and sale, agreements of purchase and sale, typically contain a no other representations or warranties clause. And this means that if there are any representations or warranties that enticed you, to purchase the home, you want to have those incorporated in your contract, into your agreement of purchase and sale. For example, if the vendor told you that the low-lying areas in the backyard are always dry and free of ponding, and you'll be able to have enjoyment there with your kids, all year round, unless that representation is incorporated into the contract, that verbal statement is not going to help you. You will not have any legal position to recover remediation if, as it turns out, his verbal statements happen not to be true. Another example of patent defects that buyers seldom consider is the importance of visiting the potential home at different times of the day and different times of the week. Some issues with a home are only discoverable under certain conditions. So make certain to visit during different weather and different times of the week. For example, you might discover that with a change of wind direction, your potential home is actually in the flight path of the airport. You want to look into that. Another example, many purchasers visit their home midweek and everything looks great, and during the daytime it's fantastic. But after moving in, they realize that, hey, rush hour, this is main activity out here, and on the weekend there's just no parking because of this or that. These types of issues would be considered patent in nature and would fall within the realm of caveat emptor, buyer beware. Be sure to ask the seller about major concerns within the home that are personally important to you, and let the seller and the agent know how important these issues are for you. Your realtor should present those questions in writing so that you have a record of the exchange. Depending upon the level of importance, it might also be advisable to incorporate that item or those items in the contract. I'll give you an example. If you have a serious pet allergy, and you tell the vendor that this is a major concern for you, and you ask the vendor whether they have or have had pets in the home, have the vendor confirm back to you in writing, and ideally incorporate this into the contract to give you the right of action against a potential breach of contract. If that representation happens to be untrue, then you may have to act legally on your best interests. So even so, if it's not in the contract, having the representation in writing should assist you in the process later on. And having also stated that that specific issue is a major consideration in you deciding to purchase that specific home would also be an asset to you, assistance to you, should future litigation be necessary. So there we have it, a quick overview of patent defect versus latent defect. Again, not legal advice, a general overview only. I do my best to personally answer each comment, each question that relates to GTA real estate. Outside the GTA, especially outside of Ontario, frankly, a realtor more familiar with the issues in your local market would be a better resource than I. But if you have questions about the GTA market, you're welcome to call me or email me, and I will get back to you personally. Thank you for watching. If you found this information helpful, please give this video a like and subscribe to this YouTube channel for more videos from realhelpfulrealestate.com. And have a great day.